because I say at the beginning we have to start with the protection, is a mandatory action of the court within the registry, with a very deep experience in how to protect protocols of protection, programs, and participation, which is a reality. So that means that outreach was done well, if I may say, because today we have, in two current trials before the court, we have victims admitted and represented by lawyers. And you can see, if you follow the proceedings of the court, that these lawyers are very active. They are submitted many issues to the chamber, and they are heard the chamber to consider these views and the legal opinion of the lawyers representing the victims. So it's a reality which also involves cost. This is a very, very delicate aspect of our action, but is essential. Without that, we can never understand how the victims in the north of Uganda needs different protection, need different assistance in respect of the victim in the DRC. So we have to deal with different situations, and this is why our action needs to be differentiated. It involves experts and expertise. It's very difficult. It involves individuals who are survivors, and this is the really daily experience. The people we meet for the first occasion are survivors. And first of all, we have to gain the trust of these persons, which is not easy. And then we have to reach them, we have to engage in a dialogue, and we have to receive from them inputs in order also to improve our models and our actions.
It would not be meaningful to the lives of the affected communities if they don't understand what these processes are. And the victims' participation, in fact, you have the silent majority of victims who will never get the chance to tell their story. And for those people, unless you have the outreach machinery to engage them, the ICC is working for a very limited number of victims. So I think the challenge for the ICC, as well as the challenge for the special court, the way it's a similar challenge, but how we were able to overcome that challenge was to set up outreach forum where we invited court officials to directly engage with the people. We call it participation, but not in the sense of the Rome Statute. Because what does that mean? The prosecutor, the principal defender, the registrar, the chief of victims and witness protection unit, and other court staff are able to directly meet with community members in very remote villages so that court officials will listen to their concerns, listen to their views about justice, listen to what they have to say about the mandate of the court itself.
Ce que nous demandons à la CPI, c'est qu'ils puissent vraiment émettre des mandats contre les dirigeants et des FRDC et des CNDP pour que les femmes puissent retrouver leur dignité. Et l'autre problème, c'est les fonds au profit des victimes. Il est vrai que le montant alloué ne suffit pas pour que la femme puisse retrouver sa dignité, qu'on puisse revoir comment orienter ces fonds, que ce soit individuellement ou dans la communauté, pour que les femmes puissent vraiment bénéficier de ces fonds au profit des victimes.
It's very important to really be there, as I told already in my first intervention, because we can also be informants for ICC as such. When you are with the victims in the villages, you just meet questions like, why, if we now talk about the host country here, northern Uganda, why are you not arresting? Why is ICC not arresting Joseph Kony? And then we have to explain something that is very difficult for most of the victims to understand. And Binta raised just here the question of that why are you defending the perpetrators when we don't have anything? And that is exactly those questions we also are meeting, that they are rich men going around in our village So it's very important that we know what is needed.
The trust fund has already managed to have a really important role in underscoring, strengthening this reparative side of the International Criminal Court, which is so vital. Recognition that victims have suffered and ensuring that these crimes do not continue is so vital to this process. And another point just to mention is that, of course, it's so important that states contribute to the trust fund to increase the resources. It's also important for states to ensure that they have the capacity to trace and seize assets in order that those assets of perpetrators can be put to the trust fund. It's also important that states put in place domestic measures in order to deal with the needs of victims on the ground, as the trust funds can only ever act in complement to national processes.
So we cannot sever the judicial proceeding, the criminal proceeding, the cooperation that we need to enforce the decision, to preserve the authority of the decision of the ICC from the protection, reparation, and participation of the victims.